Frank Anthony Michaud Jr. estate. I am the authorized representative.
I have the people P86771.
No, it's not. You have work. So
Yeah,
you're on Friday.
Are you representing at the desk? Representing yourself?
The judge needs to address you, sir.
Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry. Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can.
Full-blown masterclass in what happens when pseudo-legal fantasy collides head-on with real-world authority. We're revisiting a familiar character today, a self-proclaimed sovereign citizen, someone who believes they've cracked a secret legal code that somehow puts them above the law. And if you've seen these before, you already know how this goes. Except this time, there's a twist. Because standing on the other side of this nonsense isn't just any judge. This is the kind of judge who doesn't entertain games, doesn't tolerate word salads, and absolutely does not let people hijack his courtroom. Now here's what makes this case so compelling. This defendant genuinely believes he's in control. He thinks he can out-talk, out-logic, and outmaneuver the system using buzzwords like jurisdiction, natural person, and common law. But what he doesn't realize is that every single one of those arguments is about to get dismantled in real time. And not politely.
You want to build, Mr. Michaud?
Are we on record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You have.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
May
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all.
You can feel the tension building. And if you've watched enough courtroom footage, you know this is the calm before the storm. Everything starts off routine. Names on the record, formalities, structure. But underneath that structure is a ticking time bomb. Because the moment a sovereign citizen starts inserting their ideology into a legal proceeding, the entire rhythm of the courtroom gets disrupted. And here's the key thing to understand. Courtrooms run on order, hierarchy, and procedure. There's a reason people speak when addressed, sit where instructed, and follow protocol. It's not just tradition, it's how justice functions efficiently. So when someone walks in and immediately challenges that structure, it forces the judge into a position where they have to reassert control. And that's exactly what's about to happen. Watch closely how quickly this shifts from normal hearing to who's actually in charge here. Because once that line is crossed, things escalate fast, and judges like this one.
But I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple
no?
arguments. Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority
or
of the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is
in
not
order-
admiralty,
What is
and
it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory, that is.
It might seem small, but it's actually huge. Refusing to sit where instructed isn't about the chair, it's about authority. The defendant is subtly signaling, I don't recognize your control over me. And in a courtroom, that's a direct challenge to the judge. Now, here's what makes this even more interesting. The defense attorney is trying, very carefully, to bridge the gap. He's essentially translating sovereign citizen logic into something the court can understand. But notice how quickly that effort gets shut down. That's because these arguments aren't rooted in actual law. They're
Guided by the statutes of the state of Michigan.
Okay, so today, under which one is?
This is a criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other, it don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
delicti.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement, I have a right to see a sworn statement saying I injured someone,
There's a complaint in the file.
sworn complaint, signed, all,
You want to see it?
affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow.
It's the classic denial. Almost every sovereign citizen rejects the label while simultaneously using the exact arguments that define it. It's like saying, I'm not part of that group, while reading directly from their script. But here's where it gets really important. The judge immediately shuts down the interruption. Not because he's being harsh, but because control of the courtroom is non-negotiable. If every defendant spoke whenever they wanted, proceedings would collapse into chaos. So when the judge says, don't speak until I ask you, that's not a suggestion, that's a rule. And you can already see the friction building. The defendant wants to assert identity and independence, while the judge is enforcing structure and compliance. Those two things cannot coexist in this environment. And as this continues, that tension is only going to get louder, sharper, and far more.
Prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the
So-
OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right, and would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt, and we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a
I
question.
object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Sovereign citizen script territory. This question, are you honoring your oath to the Constitution, is designed to flip the dynamic, to put the judge on the defensive. But here's the reality, it doesn't work. Judges don't need to prove legitimacy mid-hearing. Their authority is already established by the system itself. What's fascinating here is the misunderstanding of what an oath actually means in practice. The defendant is treating it like a contract he can enforce in real time, as if catching the judge in a verbal misstep somehow invalidates the entire proceeding. But that's not how law works, and watch how the judge responds, not with confusion, not with hesitation, but with clarity. He answers, redirects, and then immediately reasserts control. Because again, this isn't a debate stage, it's a courtroom. And the rules here are very different from—
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless
a
you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied not?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objections to the
I
evidence.
object that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing,
It's
Mr.
still,
Michaud.
on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two separate?
Have you ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether whether discovery.
You don't have to tell me what they are. I know what they
I
are.
know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right,
And I'm not going to play that crap today.
right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a...
Gloves are off, the tone has shifted, and the judge is making something crystal clear. This is not a negotiation. Well, that phrase, you're not running the courtroom, I am, is the core message of this entire exchange. And look, some people might hear this and think it's aggressive, but context matters. Judges deal with hundreds, sometimes thousands of cases. When someone deliberately disrupts proceedings, wastes time, or refuses to follow basic instructions, it doesn't just affect them, it affects everyone waiting for their turn in that system. So what you're seeing isn't anger for the sake of anger, it's enforcement. It's the line between patience and accountability. And once that line is crossed, the consequences start stacking up quickly. Because from this point forward, every refusal, every interruption, every attempt to derail the process.
Waive the preliminary exam, and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to...
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me and think
okay.
listen to me.
No, I really want to address, okay, so.
I'm not addressing any of that crap you
Can
got in
you-
front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great.
you haven't-
Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of
United
that.
States citizen. I am
Stop.
actually
Hold on.
identified.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize
what-
that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you and nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on. It does, it should mean something
Can you
because,
prove it? Please prove
can
it.
I prove
then.
what?
Prove that I am not that I am the artificial person. Period.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove,
Okay, so.
hold on, you've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.